sales executive is told she is being dismissed for performance issues. She assumes there is nothing she can do because her boss has already made up their mind. A warehouse worker signs a warning letter without reading it properly because HR says, "This is just a formality." And a manager resigns immediately after a bad meeting, believing that if the situation is unfair, resignation automatically strengthens a legal claim. All three are wrong. And all three are relying on employment law myths that can seriously harm their case. So let's break down some of the most common misconceptions we see at Blackstone Solicitors, based in England, every single week. First myth: you cannot do anything if your employer has already decided to dismiss you. That is not true. Even if a decision feels final, the process still matters. Employers are legally required to follow a fair procedure. That includes proper investigation, consultation, and giving you a chance to respond. If they skip those steps, the dismissal can still be unfair in law. Second myth: if you are off sick, your employer can just sack you whenever they want. Also not true. Long-term sickness can sometimes lead to capability dismissal, but only if the employer acts reasonably. That usually means obtaining medical evidence, considering return to work options, and looking at reasonable adjustments where relevant. Simply running out of patience is not enough. We recently advised an employee who was dismissed after months of anxiety-related absence without any occupational health referral or discussion of adjustments. On paper it looked straightforward, but legally it raised serious issues. Third myth: you must accept everything written in a warning letter. Incorrect. A disciplinary warning is not automatically correct just because it is issued. Employees have the right to challenge allegations, present evidence, and appeal decisions. Accepting it without question can weaken your position later. So, the fourth myth is that resigning will improve your case. This is actually one of the most dangerous assumptions you can make. In reality, resigning can actually make claims harder, unless it's a really clear case of constructive dismissal, where your employer has fundamentally breached your employment contract. Even then, timing and evidence are absolutely critical. We often see employees resigning a bit too quickly during conflict at work, only to realize later that they might have had stronger options if they'd stayed and taken advice first. And now, the fifth myth. You cannot claim anything if you have not worked somewhere for long. That's just not true. Some rights, like protection from discrimination, apply from day one of employment. Others, such as unfair dismissal protection, usually require 2 years' service. But honestly, that doesn't mean you have no legal rights at all if you're new in a job. Sixth myth. Your employer is always right because they are HR. HR departments manage processes, but they are not the final authority on employment law. Mistakes do happen. Policies are sometimes applied incorrectly. And decisions can still be challenged if they are unfair or unlawful. Seventh myth. You do not need evidence, just your word. Employment disputes are evidence-driven. Emails, messages, meeting notes, and documents can make a huge difference. Without them, even strong cases can become difficult to prove. And finally, one of the biggest myths of all. That employment law is too complicated to understand, so there is no point trying. In reality, most cases come down to a few key questions. Was the employer fair? Was the process reasonable? And were your rights respected? So what is the takeaway? Many people lose confidence in their case, not because the law is against them, but because they rely on myths instead of facts. And by the time they find out the truth, important decisions have already been made. At Blackstone Solicitors, based in England, we help employees separate fact from fiction in unfair dismissal, discrimination, and workplace disputes. Because in employment law, What you believe can matter just as much as what actually happened.